Thank you. Good morning, everyone. I'm going to call the Assembly Committee on Judiciary to order. Madam Secretary, would you please call the roll?
Assemblywoman Bilbray Axelrod.
Here.
Assemblywoman Cohen.
Here.
Assemblywoman Gonzalez.
Here.
Assemblywoman Hanson. Assemblywoman Hardy.
Here.
Assemblywoman Kasama.
Here.
Assemblywoman Krasner.
Here.
Assemblywoman Marzola.
Here.
Assemblyman Miller.
Here.
Assemblywoman Wynn.
Here.
Assemblyman O'Neill.
Here.
Assemblyman Orentlicker.
Here.
Assemblywoman Summers Armstrong.
Here.
Assemblyman Wheeler.
Here.
Chairman Yeager.
Here. Everybody is present. That means we do have a quorum. Thank you, everyone, for being on time this morning. And welcome to members of the committee. Welcome to those joining us on Zoom, and welcome to members of the public who may be watching either on the legislature's website or on the legislature's YouTube channel. We have now arrived at day 38 of the 81st session of the Nevada Legislature. Before we get started, just a few housekeeping rules. These will sound familiar to many of you, but just in case we have new people participating, I want to make sure we get the lay of the land here. Number one, if you're on the Zoom, if you could please mute when you're not speaking, that'll help with the audio feedback. And for our presenters on today's bill, if you could remember to state your name each time before you speak, especially if you are answering a question, that'll help with preparing the minutes. I will try to remind you to do that because I know it's not a natural thing that we do in everyday life. We do expect courtesy and respect in our interactions with one another. We don't always agree on policy, and this may in fact be one of those bills where there are strong disagreements on pieces of it. That's perfectly fine, but we need to make sure we're being respectful of one another, of the legislative process, and most importantly, of our legislative staff. Finally, many members will be using multiple devices to access the meeting, including laptops, desktops, extra monitors, iPads, phones, trying to navigate this virtual world. So please don't see it as a sign of disrespect or inattention if members appear to be looking away at any point during this morning's hearing. With those housekeeping matters behind us, we will move on to our agenda. Members, as you can see, we just have one bill on the agenda today. So at this time, I'm going to open up the hearing on Assembly Bill 42. Assembly Bill 42 makes various changes relating to criminal law and criminal procedure. And before I hand the presentation over, I'll let members know and members of the public know as well that there is a proposed amendment brought by the sponsor of the bill. Members, you should have received that, I believe, a couple days ago, but it is on Nellis. It can be accessed there for members of the committee and members of the public. So we have a few folks with us on the Zoom today to present, and I think our main presenters are from the city of Henderson. They are the sponsor of Assembly Bill 42. So I will welcome Ms. Rourke and Mr. Shifalakwa from the city of Henderson to present the bill. And I know we also have Judge Glasson on with us, as well as Ms. Souza Yamas from the Department of Public Safety Records Division. So we'll let the city of Henderson present, and then I'm sure we'll have some questions for the presenters on the Zoom. So again, welcome to the Assembly Judiciary Committee, and when you're ready, please proceed.
Morning. Thank you, Chair Yeager. Thank you, Vice Chair Wynn, for allowing us to present to you AB 42. My name is Nicole Rourke, Nicole, last name Rourke, Rourke. And I'm representing the city of Henderson today, along with my colleague, Mark Skifalakwa. First, we'd like to thank you, Chair Yeager and Vice Chair Wynn, and all the time that you've spent with us on this bill, and all the members for meeting with us to help let us explain a relatively complex process bill. And so we appreciate all of your time and effort. And we'll have a presentation today. We'll walk you through the bill, as well as walking through the amendment that's been posted. So with that, I'm going to turn it over to Mark.
Thank you, Ms. Rourke. It's Mark Scifalacqua, MarkSchifalacqua. Thanks to the chair and the vice chair and the committee for hearing this important bill. Assembly Bill 42 represents a pathway forward for how we handle the many cases of domestic violence in our state and in our courtrooms. Prior to 2019, there was never a constitutional right to a jury trial for a misdemeanor in the state of Nevada. Now, on average, the Henderson City Attorney's Office prosecutes and files about 1,000 cases of battery domestic violence every year in the Henderson Municipal Court. That's 1,000 victims of abuse. And we take a lot of pride in that. We work hard on them, and we try to represent the voice of the victim and justice in these courtrooms and try to provide the victim with a level of safety and security moving forward. All of those cases prior to 2019 in all of our municipal courts and in our justice courts were heard by a judge. If someone wants a trial, that trial is heard by a judge and not by a jury. In fact, as recently as 2014, our Nevada Supreme Court said there was no constitutional right to a jury trial for battery domestic violence. While it's a serious offense, it does not require a jury trial under the Sixth Amendment. Well, that all changed in 2019 in the Anderson case. Well, what changed in the Supreme Court's mind from 2014, when they said you did not get a jury trial for battery domestic violence, to 2019? And what they said was it was the change in legislation in this body's 2015 legislative session. 202.360, that's our gun prohibition law in the state of Nevada. It lists various folks who are not allowed to possess firearms. Felons, the mentally ill, those convicted of stalking, extended protected orders, fugitives from justice. And the legislature added domestic violence, misdemeanor domestic violence. So our Supreme Court said, well, while we said in 2014 this didn't get you a jury trial, now it does. Now it rises to the level of a serious offense under the Sixth Amendment because your Second Amendment rights are affected. And that noted the legislature's intention to make this a serious offense. So, like I said, we had never had this in the state of Nevada prior to this decision. And while the decision was very straightforward, and the reasoning makes sense, it did raise many more questions than they actually had answered. First of all, are municipal courts allowed to do the jury trials, conduct the jury trials? As you know, typically cities get their power, their authorities from either a state statute, a charter, the Constitution. Well, none of those expressly say that the municipal court can comply. Although Anderson was a Supreme Court case, it was constitutionally based, and it was a municipal court case. Do we have time to make some infrastructure changes? There are not jury boxes by and large in our municipal courts throughout the state. And there's good reason for that. And that's because there was never any statutory or constitutional right to a jury trial. So they're not really built for juries. What rules do we follow? We want to make sure we're doing this consistent across the state so we don't have different jurisdictions doing different rules. And so what rules do we follow? These were big questions. As far as the first one, are we allowed to conduct a jury trial to comply with the Sixth Amendment? My position has always been yes. I've been pointing to this case, and I've been arguing this case in every courtroom that I've been in front of on this topic. 1995 case out of the Supreme Court of our state, Donahue versus Sparks. A Sparks municipal court judge ordered a jury trial for a DUI. Now, there was no constitutional or statutory right to do so, but that judge did it. And the Supreme Court says, well, listen, municipal courts really don't have that authority to just discretionary do that, unless it's required by the state or the federal Constitution. Well, my argument has been, well, that's exactly what we had in Anderson. A constitutional rule that you must comply with, a due process right. That argument has been successful throughout the district courts that we've argued this in front of. These are 3 cases here in the 8th Judicial District Court, 2 Henderson cases from the Henderson Municipal Court and 1 from the Las Vegas Municipal Court. 3 different judges, 3 different district court departments, but the same ruling throughout. Obviously, the cities can comply with this ruling. You're operating a court. You have to provide a level of due process. And this is what the Constitution says now is that level of due process for certain battery domestic violence cases. But to be clear, this is not statewide yet. While I expect the Supreme Court to take this up, there has been no ruling yet, and I would not expect a ruling during your legislative session due to the briefing schedules. But clearly we believe we can. But that hasn't stopped the challenges we've got. We have gotten challenge after challenge after challenge to our authority to be able to provide a jury. And that's caused problems because we need to make the investment to be able to accomplish this. And a lot of these challenges have made that very difficult. But even if we do have the authority, which I think constitutionally we do, our Supreme Court has said that even if we order that, a jury trial for a misdemeanor at some point, you really can't do these without rules, without statewide rules. This is a 1988 case, Blanton versus the North Las Vegas Municipal Court. And it said simply that. It was in this case analyzing a DUI, whether a DUI gets a jury trial, right? They answered no, but they also said that even if we order this, you're going to have to wait for the legislature. It talked about how you summons a jury and the rules of procedure. And it talked about a decision requiring this in municipal courts could not be implemented until those procedures were developed. And the legislature, which meets once every 2 years, is not presently in session to fill the void. So we had a question. Where does this all leave us? It's September of 2019. A legislative session had just ended. We are being challenged about our very authority to provide the jury trial right. That's in litigation. Our Supreme Court says you really can't start this without legislation and clear rules. And there was a whole lot of daylight between September 12th, 2019, the date of the Anderson decision, and March 10th of 2021. Domestic violence, as you know, doesn't stop. It won't wait for a legislative session. It won't wait for a Supreme Court ruling. Victims of domestic violence have a constitutional right to speedy justice. And sending these cases somewhere else or dismissing all these cases in hopes of somebody else that would take care of our problem was never an option. We had a duty to these victims, and we couldn't turn our back on them. These are our cases, and this was our responsibility. So what could we do? We found a solution, and it was temporary. We enacted in the city of Henderson, as well as other cities, an ordinance prohibiting domestic violence. Cities have the authorities, as you know, to make their own ordinances and crimes. And that's what happened. Now, why did this help us? Well, it only helped us temporarily. But the law is that an ordinance does not prohibit somebody from having a firearm. And therefore, there's no accompanying jury trial right. So this allowed us to continue to prosecute. It allowed us to continue to fight for victims, but it was temporary in nature. It was something where we always wanted to get to a point where we're in front of this body. Okay. So this is a big problem. We've never done this in Nevada, but it's not impossible, and we're not going to give up. So what is this bill? Well, One, it would provide clear language that the municipalities can comply with the Anderson decision. We have the discretion to be able to conduct the jury trials. To be clear, this is permissive. It doesn't force a city to go ahead and start constructing and hiring personnel. We certainly would in our city due to the volume of cases we had, but perhaps a very small city would want their maybe county district attorney to handle instead. But it would provide that. It would provide the rules for the municipalities. Chapter 175 is our jury trial rules in the state of Nevada. It would insert us in there so we know exactly what rules we're following. So we're doing these consistently throughout the state. And it would also provide some clarity on the federal definition of domestic violence that's listed in 202-360. So we know exactly who's entitled to a jury trial and who is not. So we're providing the appropriate level of due process in our court system. So if I could walk you through the bill, I would appreciate it. Section 1, what that says is if there is a felony and a misdemeanor domestic violence charge together, that you would do one jury trial, not two. We don't want victims of violent crime to have to testify more than they absolutely need to. So if there was a case of a kidnapping or a sexual assault or a battery with a deadly weapon, and part of those facts also included a battery domestic violence, that case could be tried as a whole in the district court level in front of a jury, not a trial in the justice court in front of a jury on the misdemeanor, and then a trial in the district court on the felony. Same incident, it should be heard together. And that would provide a level of certain appropriate due process to a defendant, but also protecting the victim's right of not having to testify unnecessarily. Section 2 of the bill cleans up some language regarding whether a defendant needs to ask for a jury trial, whether he or she needs to request a jury trial, demand a jury trial. There is a section in there that refers to that. That's a little bit more with some civil law, and we're saying if you have a constitutional right to a jury trial, you don't have to file a demand anymore. In other words, if your Second Amendment rights are affected, then you have that right to a jury trial. You don't have to ask the court. It would be automatic, just like how a felony offense would be. Section 3 adds municipal court to the jury size of that's already present in the NRS. It just adds the word municipal court along with justice court. Sections 4 and 5 just clean up some language regarding instead of district attorney or state, now we'll have city attorneys prosecuting this offense. So it's going to say prosecuting attorney, just a little more generalized. Section 6 expands those who can provide, you have to provide a jury deliberation room for a jury, as you know. The statute right now says that's the duty of the sheriff of the county. We're just adding chief of police. Practically, that's usually just done by somebody in the courthouse building. We don't have them go over to the police department, but that is how the law reads right now. And Section 7 permits the municipal courts to use sound recording equipment to record the jury trials as long as they're courts of record. So just some procedure. Sections 8, 14, and 15. These are the municipality sections of our NRS. NRS 5 deals with municipal courts. 266 are those cities that are incorporated under the general laws of our state. And 268 is the ones that are incorporated under charters or incorporated throughout our state. And it's consistent throughout. It simply says that a municipality can comply with the Constitution and allow a jury trial. It's just the authority sections. Section 6 deals with who we send the jury summons to based on population. If you have a large city above the population cap, you can send it out to your city residents. But if you don't have a significant population in your city, you could send it county-wide. So again, you're not sending summonses out to the same people over and over again in a smaller area. And also the city can contract with another court's jury commissioner for services if that person would enter into a contract. Section 10 permits the chief of police to serve summonses. Again, it says the sheriff does that. In that section, we're just adding chief of police. That's consistent with cities. Functionally, as you know, a jury commissioner is the one that mails these out. It always has the effect of law enforcement, so people don't ignore their jury summonses, but just adding some city terms into that. Section 11 is the compensation for jurors. As you know, you get paid to be a juror. It's $40 a day. Nobody gets rich doing this, but we would pay at the same rate that's in the statute. And Section 16 just has some basic conforming language regarding jury selection. Section 12, now 245 is our battery domestic violence law in conjunction with Section 33.010.1018. And that just really codifies the Anderson decision. And what it says in there is if you're charged with this law, with this offense, and your gun rights are affected, you are entitled to a jury trial for this offense. Section 13 amends the definition of 202.360, clarifies language to ensure we're dealing with convictions from ours and other jurisdictions. That includes same or substantially similar conduct convictions. That is consistent with other parts of 202.360, including stalking. Other places call battery domestic violence perhaps by a different name. They call it domestic battery or things like that. But as long as the elements are the same, it would be equivalent, as well as stalking is the same in the statute. We do have a few amendments. We've been working with a very large group to try to accomplish this. No doubt this type of an undertaking does affect a lot of people, cities, counties, prosecutors, defense attorneys, courts, victim advocacy groups. And so we've been reaching out to many and having a lot of discussions. So we make sure that this works for everybody that it can work for going forward. So Section 3 talks about how many jurors you need for misdemeanor jury trial. It is in the law right now that says 6. We're just saying a minimum of 6. Little flexibility there in case a court ever ruled that you needed more jurors for this type of a process, but 6 would be the goal. Section 4 we worked on with some Las Vegas Justice Court judges who have heard a couple of these jury trials since Anderson came into effect. When you have a 6-person jury and you have 4 preemptory challenges, it gets to be tough to pick a jury because you're kicking so many people, 4 on each side. So you get 4 on each side. The amendment would be for a felony or a gross misdemeanor. That would remain the same, 2 each side for a misdemeanor. Keep in mind, you'll always get an extra strike for the alternate juror. Section 6 and 10, just insert the word chief marshal. This was done at the request of the city of Reno, who would have their chief marshal do some of these functions, perhaps providing the jury room, deliberation room, and then as well as providing who could send out the jury summonses. We worked on the definition in 202.360. 202.360 again is our gun prohibition law and lists out the different individuals that are prohibited possessors in our state. And this is where in 2015 the legislature inserted misdemeanor crime of domestic violence. We wanted to be a lot clearer on who this encompassed, who was in and who was out. Because there is some ambiguity about that when we're referencing a federal definition and not our own state definition. So we wanted to be clear that we're talking about battery domestic violence. And it must be that offense, battery domestic violence. That's what Anderson talked about. That's the offense that someone would be a prohibited possessor. And that's the offense somebody would get a jury trial for, not other offenses. And we also talked about who it would be against, the person's spouse or former spouse. That's the same. There's no changes there to the current definition in the federal law. Dating relationship as defined in Nevada law, there is a definition of that. And so that has been on the books and tested. If the defendant and the victim had a child in common, that's also the same as the federal definition, or the child-parent relationship going either way. The reason why we need to change this definition is because of the ambiguity. And remember, with Anderson, you only get the jury trial right if Upon conviction, the person would be prohibited from having a firearm. It wouldn't be for every offense. That's where the federal definition of domestic violence hasn't really worked for us or for anyone. There was a case in 2009 from our US Supreme Court called United States versus Hayes. It's pretty dense and talks about a bunch of grammatical rules, but what it really said was this. You could be charged with an offense, say battery, not battery domestic violence, just battery. As long as the underlying relationship would qualify, for instance, that you were married or that you had a child in common, even though that wasn't charged as that offense, even though it wasn't pled as that offense, even though the person wasn't convicted of that offense, just the battery, that would actually make you a prohibited possessor under federal law. And so unfortunately, this federal definition has in a way broadened the prohibited possessor statute to crimes that no one ever thought about. Battery, assault, coercion, anything with a forceful type of an element with an underlying or qualifying relationship. So, we want to be very clear who we're providing this jury trial right to and who we're not, and who's a prohibited possessor. It is not our intent to include folks charged with simple battery or simple assault. As a prosecutor, sometimes you use discretion on those cases of not charging somebody with our domestic violence law, perhaps due to the severity of the incident or what they undertook as far as counseling on their own. Maybe you don't think those penalties are needed, and so you charge them with the lesser offense. What we don't want is that person to be a prohibited possessor, because that was never the intent of anybody. And that's the problem with the federal definition. It's going way beyond Anderson, and it's causing confusion in our courts. So the difference between the federal definition that we rely on right now and what we would change it to. So spouses and former spouses would be the same. Child in common would be the same. Right now, the federal definition, parent striking child would qualify, but not child striking parent. So this would go both ways. The federal definition then says this, and this is where it leads to confusion as well. It says that if you're similarly situated to one of those relationships, similarly situated to a spouse or a parent or a guardian, well, what does that mean? Well, there's some case law on that. They talk about, usually it's cohabitating for a period of time, perhaps sharing expenses, expectations of monogamy. So something more akin to a spousal relationship. Certainly something that's gone on for more of a long-term relationship, or again, living together for a decent period of time. So that would be similarly situated. But that's what's been problematic. This is typically referred to in the federal law as the boyfriend loophole. It does not include a normal dating relationship. And many times these relationships are where we see a high level of violence. So currently, under our state law, which uses the federal definition, it would not include many dating relationships. So you would have scenarios where a husband abusing a wife could be prohibited, but not a boyfriend abusing a girlfriend. So that's certainly a policy issue, and we think should be changed. But also we need to remember our Nevada law is broader than the federal law. And so a dating relationship qualifies as a domestic battery in the state of Nevada. So here's where the issue comes in. We need to know who to provide this jury trial to. And we need to know that from the get-go. We need to know that from the arraignment, when somebody pleads not guilty to an offense, so we can make sure we give them whatever process is due to them. And the federal definition doesn't do that. Here's why. When a police officer arrests somebody for domestic violence, they're dealing with a very volatile situation. They're trying to calm people down. They may be trying to attend to injuries. And they're going to learn if they were in a relationship. Yes, we've been dating for 6 months. But they're not going to know all of those factors about whether or not this is akin to a spousal relationship. They're going to arrest for domestic violence, appropriately so under our law. I don't know how we're going to determine, if we leave the federal law as our definition in the state of Nevada, how we're going to determine who's entitled to the jury trial and who isn't. Because remember, they're really tied to one another in a sense. You don't get the jury trial unless the Second Amendment rights are violated. So we need to know who is in and who is out. And we need to know that from the get-go. And that's the problem with the federal definition. One, it's encapsulating crimes outside of Anderson. That's how it's been interpreted by our U.S. Supreme Court. And two, we're excluding some dating relationships. But that being said, we don't know where the line is. Last part is the federal definition can always change, as you know. Congress can always change that. If we defer to their definition, we could wind up something that maybe we're not happy with. The last amendment, so that was the reason for that amendment, to provide some clarity of who we're providing this right to. And lastly, we had an amendment. This was requested by, I believe Judge Glasser was on the phone or on the Zoom call, and some of the other judges in some of the smaller townships. And it's something akin to what we did with the cities. If you're in a smaller township, you could send your jury summonses countywide. If you don't have a population base to really support the jury summonses continuing to go to the same people. So I wanted to thank you, certainly stand open for any questions, but this bill does represent how we can move forward with handling domestic violence in our court system in our state.
Thank you so much, Mr. Shifalakwa. Before we go to questions, I did want to take an opportunity to recognize Judge Glasson and ask if there was anything you wanted to add on that very last amendment that was just presented.
Thank you, Chairman Yeager. This is Richard Glasson speaking for the Tahoe Justice Court and for a large part of the membership of the Nevada Judges of Limited Jurisdiction. This amendment's somewhat necessary for some of our outlying rural townships that might be in a county with a larger population, such as Douglas County or Washoe County, specifically the Tahoe Justice Court, the Incline Village Justice Court, where we're going to be going back to a very, very small pool of jurors in these jurisdictions where we might have a high population of tourists and guests, but not a large population for jury pools. The current law anticipates this, for example, in Clark County, where in, say, Mesquite or Laughlin, those judges can draw countywide. We don't have that same ability in counties such as Elko County with the Carlin Township or the Wells Township, and then again, Douglas County and Washoe County. This allows a net to be thrown so we're not pulling the same people in ridiculously often. I have 6 jury trials on hold and a population in my township of under 2,000 people. I think this is a necessary amendment. The summoning of juries for criminal actions in justice court is conducted in the same way as we do in civil, and civil is where we'd be changing that particular statute. And I'm available for questions if I can help with anything else.
Thank you so much, Judge Glasson. It's good to see you this morning in Assembly Judiciary. I know we're going to have questions from members. I just want to kind of ask a couple out the gate to Mr. Shifalakwa. And I think the first one is about Section 13 of your amendment. So, you know, you indicated that the original language as it exists now is it refers back to the federal statute. That's how it exists currently in law. And then the original bill, AB 42, was going to simply reference our state domestic violence law. But then in the amendment, what we essentially have is a carve out to say, well, we're not going to include all of what is domestic violence in the state of Nevada, but we're going to specify which parts of the domestic violence statute should be included in the prohibited person statute. And I just wondered if you could kind of walk me through the thought process. I think we have 4 different items in the amendment in Section 13. If you could walk me through the thought process of the inclusion of those 4 and why you believe that those are the right ones to identify as prohibitors for firearms?
Of course, Mark Skifalakwa. As you know, in our Nevada law, really any relationship by blood or marriage would qualify as a domestic relationship as far as a domestic violence charge. And so we were trying to balance a few things, understanding that the Second Amendment is a big deal. It is a big deal takeaway. We want to make sure we're targeted as much as we can. We know that folks who are abusers who have access to firearms are more dangerous to their victims. And so we were looking at what are the relationships where we see the highest level of violence. And that's why we try to target these. There may be very good reasons why we incorporate all relationships by blood and marriage in our domestic violence laws, but as far as where we see the highest level of violence, it would be these relationships.
Thank you. And then the second question I have maybe is a little technical, and just kind of want your thoughts on it. But, you know, before I get there, I should add to the committee, we did add the Anderson case as an exhibit on Nellis. So if anyone's interested in reading the court opinion, it is up there now. It's not terribly long, so it's relatively easy to get through. But if you're interested in diving a little bit more into that opinion, it is up there. And as indicated, that opinion came out, I think, right after we finished our last legislative session in 2019. So the next question that I had for City of Henderson is this. So if we have somebody who is already a prohibited person, let's say we have somebody who's convicted of a felony. So under our laws, they would not be allowed to possess a firearm. If they are now charged with a domestic violence offense that would fit under one of the categories in your amendment in Section 13, would they still get a jury trial under, I guess, under either your reading of Anderson or under the court practice? Or would the thought be, well, since they're prohibited already, they're not going to lose a right that they've already lost, so they wouldn't get a jury trial in that circumstance?
Mark Skifalakwa, that's a great question. That has not been litigated yet, and I wouldn't say the bill directly addresses that question. As you know, the reasoning in Anderson was if you're going to lose your Second Amendment right, then you're entitled to a higher level of due process. And you make a good point of, well, what if you're already a felon? You can't have it anyway. Why are we going to do this? This bill doesn't address that. I think, to be honest with you, that would have to be addressed by a court if that was brought up, but I don't know how a court would rule on that.
Thank you. And yes, of course, the bill doesn't really speak of that. Maybe we'll just have to get some further guidance from our Nevada Supreme Court at some point on that particular question. I don't doubt that it'll be litigated probably in some fashion. So thank you for that. And I know we have a number of questions. Members, if you could maybe just raise your hand in front of your screen to let me know if you have a question. And I'm going to put a list together here of who I see with hands raised so far. Okay, so this is the list so far, and then I'm sure we'll have more questions, but we're going to start with Vice Chair Wynn, then we're going to go to Assemblywoman Kasama, Assemblyman Wheeler, Assemblyman O'Neill, and Assemblywoman Hanson, and we'll take it from there. So Vice Chair, the floor is yours.
Thank you. Rochelle Wynn for the record. Thank you guys for presenting this bill, and I really do appreciate you guys over the past probably year. We've been talking about this. I know that since the Anderson decision came out in the fall of 2019, we've been having some ongoing conversations about how we will do this. So I'm going to kind of start with some of the easier questions that are more of the technical questions regarding like preemption. I know that across the country for misdemeanor jury trials, they often use like veneers of 6-member juries. Is there any reason or how you came up with the number of preemptory challenges that you were including in that?
Mark Skifalakwa, yes. So as you know, with a 12-person jury that you would have for all your felony offenses, non-life felony offenses, each side gets 4 peremptory challenges. We simply, if we're cutting the jury size in half to 6, we're cutting the peremptory challenges down by half as well. So 2 instead of 4. And again, that was with some consultation with the Las Vegas Justice Court judges just to make the jury trial process somewhat more efficient.
And I'll just jump in for 1 second, if I could, Vice Chair, just because we have members on the committee who are new to the committee and perhaps are not attorneys. I just wanted to explain the difference between the challenges that we're speaking of. So if any of you watching court dramas on TV, if a potential juror has a bias, they can be removed for cause, essentially. You can challenge that juror and say, well, this juror can't be fair and impartial, and that would be a for cause challenge. What we're talking about when we talk about peremptory challenges are each side gets to just remove a juror for really whatever reason they want to. With some exceptions, you can't remove a juror based on race or sex or protected categories. But if you're just getting like a bad feeling from a juror, you don't think they like your client, you can remove them. So when we're talking about these challenges, the peremptory challenges, those are essentially the challenges the attorneys can make or the parties can make without any cause whatsoever. So I just wanted to explain that in case it wasn't clear. And again, I reiterate that we should probably be getting continuing legal education credit for these hearings, but we'll still work on that. So thank you for that indulgence. Vice Chair Wynn, please go ahead.
Or at least for the people that didn't go to law school, it could be counted as the first year of law school. Yeah, so I appreciate that. I know that there had been some amendments and there were more preemptory challenges. So after your conversations with the Justice Court, which actually started instituting misdemeanor jury trials after the Anderson decision, is that where kind of some of that reasoning came from, is their experiences?
Mark skipped a lot, but yes, it exactly was. They said that trying to seat a 6-person jury with 4 strikes on each side, plus again, 1 always for the alternate, that it just really took longer. The jury selection process almost went longer than the trial itself.
And then you had mentioned that in the city of Henderson that you see approximately 1,000 battery domestic violence cases that you are prosecuting. Are you familiar with any of the statistics for some of the other jurisdictions, whether it's the city of Henderson, the city of Las Vegas, city of North Las Vegas, city of Reno and Sparks, or any of these other jurisdictions?
I am familiar with the larger cities in Clark County, Mark Skifalakwa. So between the 3 major cities in Clark, Henderson, North Las Vegas, and Las Vegas, there's approximately 7,000 a year. And that's actually, just for reference, more just with those 3 cities than the Clark County District Attorney's Office handles with the public defender in the Justice Court. So we actually have a higher volume in the cities than they actually do in the county.
And it's my understanding in reading the language of it enables like jurisdictions like yourself to be able to have those jury trials, 1. And 2, if you have a smaller jurisdiction or a rural jurisdiction, would they be able to, use jury services from another jurisdiction, or would they be able to send their cases to a corresponding or local justice court? How does that work?
Mark Skifalakwa, yes, the language here is permissive. I think the prosecutor who's going to file the charge just has to know that if somebody's Second Amendment rights are going to be affected by the conviction, wherever you're filing that offense, that person is going to be entitled to a jury trial. So a city like Henderson that has a large volume of these cases, we would build the apparatus to do this here. But this may not make sense, as you say, to do this perhaps in a very small city where there's 4 or 5 a year as opposed to 1,000. In that case, what the prosecutor could do is refer those cases to their county district attorney to file in the Justice Court. So this doesn't force a city to do it if it doesn't make sense. And it may not make sense for every city.
Thank you. And now I'm going to kind of go to the section 13 that has to do with NRS 202.360. That is kind of expanding and not expanding, but specifying what counts as a domestic violence conviction, or what you can also, the prosecutor's office, like a felony prosecutor, could charge someone with that felony possession of a firearm by a prohibited person. That's correct, right?
Mark Skifalakwa, yes.
What types of crimes under this definition do you think would be excluded now that were previously included, but now would not be included for purposes of a battery domestic violence conviction, where you also corresponds to losing your Second Amendment rights? Like, who did we take out?
Yeah, Mark Skifalakwa, yes. With the current definition, because of how I mentioned that our U.S. Supreme Court has interpreted this, Any type of a violent crime like a battery, assault, a coercion that has the elements of force or violence, those simple coercion, a simple assault, a simple battery is currently included under our federal definition that we refer to in our state law. That would not be the case moving forward. We are trying to just limit this to battery constituting domestic violence. That's who would be prohibited if they meet one of these categories, and that's who would be entitled to the jury trial.
So this would exclude like brother-in-laws or uncles or nephews or those type of relationships. Is that correct?
Mark Skiffalacqua, yes, it would, and that's why we were trying to be targeted. Our Nevada law, as we mentioned, as you know, is pretty expansive on what a domestic relationship is. As far as the Second Amendment issue and the prohibition, we are narrowing that to just a few relationships.
And then this would include people that are not included in that federal definition. Is that correct?
Mark Skiffalacqua, it would include certain dating relationships that are not included in the federal definition.
Okay. And was the intent in including that was to capture kind of that intimate partner violence that you're hoping to prevent or deter as a prosecutor?
Mark Skiffalacqua, yes, it's twofold. One is more the practical reason of trying to determine who gets the jury trial and who doesn't from the start of the case, and you're not always going to know if that individual is similarly situated to a spouse from a police report or a witness statement. And the second part is that we do see a high level of violence in intimate relationships, but perhaps folks are not living as spouses or cohabitating for a long period of time. So yes, it was to capture those type of relationships where we do see a high level of violence.
And Chair, I have one last question, if that's okay.
Please go ahead.
My final question is I know in light of the Anderson decision, there was confusion amongst many of the municipal court jurisdictions or other jurisdictions that just did not have the resources, the capability to conduct jury trials, also did not think they had the authority under existing case law to do so as well. And many of those jurisdictions, including the city of Henderson, passed ordinances. I appreciate the fact that you guys as a city chose to bring this, to authorize it, because I know at the time there was some concern because the city ordinances, the argument was, oh, it doesn't affect your Second Amendment rights because we're not increasing penalties, we're not following the rest of the state law and federal law in that area. Do you see, would you continue to charge under that City of Henderson ordinance, or would you now revert back to the NRS?
Mark Skiffalacqua, the ordinance was the Band-Aid, but it wasn't the cure to this problem. This is the cure to the problem. And so going forward, Vice Chair, either way you would charge it, you would be entitled to a jury trial. The reason why I say that is the amendment to 202-360 says a violation of our state law or any jurisdiction that has a similar law, and we have a similar law. So either way you would go, you'd be entitled to the jury trial going forward.
Thank you. And Chair, thank you for your indulgence. You know, it's not every day. Usually I'm on the other end with Mr. Skiffalacqua, so it's kind of fun to be able to cross-examine him. So I appreciate your indulgence in answering those questions and allowing me to ask.
Thank you, Vice Chair, and thank you for your work on this issue. I know you've had a lot of conversations with municipal courts over the interim to try to get a solution here. So, you know, I was one of those people after the Anderson decision came out that was calling for a special session to address this problem. And I think perhaps we did the right thing. We took a little bit more time to figure out what the solution should be rather than jump into a special session. And Vice Chair, I appreciate your work on that issue. Okay, we're going to move along for additional questions. We're going to go next to Assemblywoman Kasama.
Thank you. Had to find my unmute. Thank you, Chair, for allowing me to ask the question. And thank you for that great presentation by the City of Henderson. The way you walk through the sections and the changes is probably one of the best presentations I've seen. for bills that have come up. So it really helped to clarify, the important changes you're looking for. And I can certainly understand this catch-22 where the Anderson case is requiring you to do something and there's nothing in the books to help you do that. So certainly seems like needed legislation. I guess my question is that in section 13 with the federal definition, and then we're going to this definition, which is more specific, but it seems like it also broadens it a little bit with the dating relationships, which the federal doesn't seem to do. And then doesn't that increase your caseload and overburden the city? Because it seems like you're trying to make this narrow so that you can handle these cases. And unless I'm not understanding this correctly, it seems to me that this would perhaps expand the caseloads. And so just trying to understand that a little bit better.
Mark Skipalakwa, yeah, that's a great question. It expands and it contracts. And so in the end, it may be a wash. You're absolutely right that this will capture a dating relationship that may not be captured in our current definition in the federal law. But going back to that one case I cited, we're also deleting some cases that we may have had to try in front of a jury, a simple battery, a simple assault, because of the way that federal definition has been interpreted. So it expands on one end and it contracts on the other.
Thank you.
Let's go next to, let's go next to Assemblyman Wheeler.
Thank you, Mr. Chairman. I appreciate it. I've looked at this inside out, right side up, upside down, every way I can possibly look at this thing. And I kind of like, I guess, a lot of this bill. I think the first part of the bill is pretty good. But I do have a huge problem with some of it as well that would definitely have me voting against this bill in its current form. One of those problems is that under this particular section, if we change it, we've got people, I think I saw a thing on the news last night that Nevada is now 5th or 6th or 7th on people moving into the state. Okay, so a lot of people coming from other states. We also obviously have the biggest tourist population anywhere in the world. And people coming into this state who are either tourists or are moving here, people who have been law-abiding citizens up until that time when they come in, say they made a plea 5 years ago, 10 years ago to a misdemeanor, just to shut off the case. They knew they wouldn't lose our gun rights, et cetera. So I'm wondering how many law-abiding gun owners, through no fault of their own, they've already passed a background check to come in here, but this is on the books, and now all of a sudden when they cross that state line, since we're not using the USC code anymore, how many of them become felons for illegal possession of a firearm? Do we have any numbers on that? And what are we going to do with these people?
Mark Skipalakwa, thank you for your question, Assemblyman Wheeler. That would depend, obviously, if the person was already prohibited under federal law, which would apply to the whole United States, obviously. If it was a spousal battery in another state, moving here isn't going to change that. I guess if the question is, if they battered a girlfriend in another state, and then let's say that wasn't illegal there as far as a gun prohibition, and they moved to Nevada, and it was under this change. That I understand the concern. I would also say that about 30 states have laws that are more restrictive than the federal statute, and so that's not a unique issue. That would occur in many states where people would move to. Most have, or many of the states that have looked at this don't have this federal definition.
Okay, thank you. But the way I read this, I'm sorry, Mr. Chair, may I continue?
Yes, please go ahead.
Thank you. The way I read this, anyone now who is convicted of misdemeanor battery, their gun rights are taken away. And so if they're convicted of misdemeanor battery in, Tupelo, Mississippi, move to Nevada, or just come here for the SHOT Show, and we have reciprocity on a CCW, whatever, but they're carrying a firearm or possessing a firearm, then they would be a prohibited person in, as far as carrying coming into the state. And it seems like it would really expand who is prohibited, due to prior misdemeanor convictions for domestic battery.
Mark Skipalakwa, the intent here is just, to be clear, to limit the gun prohibition to battery constituting domestic violence that would have had to been charged that way and convicted that way. But I do appreciate the comment.
Okay, thank you. I see what the intent is, but I also see what the law says. And I think, if we pass this, we got a whole lot of people that are going to be, prohibited carriers all of a sudden.
Let's go next to Assemblyman O'Neill.
Thank you, Mr. Chair. I guess I'm channeling, separated by yards and concrete, Mr. Wheeler's thought pattern. Mr. Lautenberg, I appreciate the intent in the first part of the bill, but let me ask you, I'm trying to remember, I want to talk about retroactivity of this, unintended consequences possibly, particularly in law enforcement. Several years ago, when the federal prohibitors came out, my agency, along with numerous other agencies, had to discharge police officers because they weren't allowed to carry firearms anymore. They had years prior had pled guilty to a misdemeanor offense that was now a prohibitor. They can no longer carry, so they lost their jobs and had to go do something else. I'm looking at this law. Does that happen again? You were saying city ordinances, so an officer had pled guilty to a battery. It's a city ordinance. He could keep his job, but now in retroactivity, he would lose the job with the passage of this, as it, I was going to say currently written, but even with your amendment in there. Could you respond to that? That's, and it's somewhat along also with Mr. Wheeler's statement about unintended consequences here of people coming in that in their home state were allowed, but come here and are not allowed.
Mark Skipalakwa, it is not our intent to make this retroactive. I understand the concern. If we can go back to the 1996 Lautenberg Amendment, which is the federal law that said if you have a misdemeanor conviction or certain misdemeanor convictions that you can't have a gun. There was obviously people before that law was enacted that had a misdemeanor domestic conviction, right? And then the law was passed, like you said, the federal law was passed. That was not unconstitutional at that point, and it has never been found unconstitutional as far as an ex post facto law. That being said, that is not our intent with the bill here. And so if there's any potential amendatory language to make that any clearer than it already is, I'd be happy to consider that. That is not the intent here. The intent is to go forward, not backward.
If I may, Chair?
Please go ahead.
I appreciate that offer, and I think we'll work on that. The other question, and I want to make sure, not being an attorney, completing my first, or at least I'm in first semester of law school. Help me understand. So if this law passed with the amendment, how about people that had pled guilty thinking that they wouldn't lose their right to bear arms? Could they now ask for a jury trial so they could, and do lose, could they come forward and ask for a jury trial?
Mark Skipalakwa, typically how retroactivity works is if there's a new law or if there's a new case that comes out, it usually applies to cases that are open, not closed. So meaning if the person was already, say, pled guilty, had been sentenced, everything was over, no, they wouldn't be resurrected from the dead in a way. It would really just apply to cases that are pending, that are opening, that haven't been resolved.
So we've got to make sure there is no retroactivity applied in this law.
Mark Skipalakwa, and that is our intent. It is to go forward.
I appreciate that. I may think of something else, but for now, Chair, Mr. Skipalakwa, I appreciate the time.
Thank you, Assemblyman O'Neill. We still have some additional questions. We'll take Assemblywoman Hansen's question next.
Thank you, Chair, for the opportunity, and thank you for being here. My very professional notes, Fed, State, Anderson, it's a lot to to take in on a morning meeting, but I appreciate some of the dilemma that you're up against. But I do have some concerns. I was curious, what aside from Henderson, do you have other municipalities that are supporting this legislation?
Mark Skiflakwa, thank you for your question. Yes, I believe a representative from the Las Vegas City Attorney's Office is on the line to offer their support. I believe the City of Reno will be on the line to offer their support. And I believe the Clark County District Attorney's Office representing the District Attorneys Association will be on the phone offering their support.
Any other questions, Assemblywoman Hansen?
Not now, but I'm sure I'll come up with more.
Okay, great. Thank you. We'll take a question next from Assemblywoman Summers Armstrong.
Thank you, Chair Yeager and representatives from the City of Henderson for your presentation. I'm hearing concerns about retroactivity and rights for gun owners, but since you are the attorney who is actively participating in these domestic violence misdemeanor situations, could you kind of speak to us about a couple things? One, are there any other places in the United States, and someone actually mentioned possibly Mississippi, where if someone is convicted, they lose their right to bear arms if they are convicted of a domestic violence situation? Can you confirm that, or can you just at least give us a small list of other places where this is currently in law? And then I have a follow-up.
Yes, of course. So throughout the country, the federal law applies to everybody. So if there was a misdemeanor crime of domestic violence between spouses, former spouses, child in common, or similarly situated to those relationships, people would be prohibited throughout. Many states, though, as you mentioned, go further and provide additional protections that are above and beyond the federal definition. There are approximately 30 states that offer those type of protections, and many of which offer the protections for dating relationships. So a state can always define who's prohibited in a different way than the federal government. As far as examples, I do have a list, and I'd be certainly happy to share that with you after.
I think it would be important if you list a few of those here so that people can see that we are not extraordinary in this situation. And then I will have a follow-up. Thank you.
Of course. Mark Skiflakwa, Arizona, California, Connecticut, the District of Columbia, Delaware, Hawaii, Illinois, Kansas, Louisiana, Maryland, Massachusetts, Montana, Nebraska, New Hampshire, New Jersey, New Mexico, New York, North Carolina, North Dakota, Oregon, Pennsylvania, Texas, Utah.
Thank you for that. Chandra Summers Armstrong, Assembly District 6 for the record. I keep forgetting to say that. This is your space, and you understand from a prosecutorial perspective this area much better than those of us who are not trying to go to law school sitting on this committee. And just from a civilian perspective, when you see folks who are involved in domestic violence, do you know any of the statistics about possible death statistics, or what are the things that you are seeing on the other side of this issue when guns are in play? when we are talking about domestic violence? Thank you, Chair.
Thank you for the questions. And Mark Skipalakwa. Yes, I believe Nevada ranks in the top 5 throughout the country of the number of domestic-related homicides. And certainly those, the vast majority are by gun violence. So we're one of the worst throughout the country. More than half of all intimate partner homicides are done by dating partners. And so that's why we believe that one provision is important for Nevada law. The states that have gone further than the federal law have seen a 16% reduction in their gun violence or gun homicides between people in domestic relationships. So that's another reason we see it's important. To be clear, not everybody who's charged with battery domestic violence is going to, kill somebody or anything like that. That's just where experience comes in and trying to reach out to victims early to get the background. Was this a one-time thing where people were just drinking too much and things got out of hand, and maybe some counseling is okay going forward, and maybe that individual doesn't need to be a prohibited person. But we do see the other side of that penny as well, and that's folks who are in a consistent cycle of violence and can't get out, and things are ratcheting up.
Okay, are there additional questions for our presenters at this time? Assemblywoman Hanson?
Yeah, sorry about that. I told you another one would come to my mind in that previous discussion. So what about somebody who maybe they committed a crime decades ago, but not an offense that would make them like a prohibited possessor? But if we pass this law, would they automatically perhaps become a prohibited possessor, and they could face a felony charge because they currently possess a firearm that they even maybe, they passed a background check for in the past? Those are some of the concerns I have about, some of the sections of this, although overall I get the intent.
Yeah, Mark Skipalato, and that's a valid concern. In our state, at one point, we enacted the law that if you're a felon, you can't have a gun, right? And somebody was prosecuted later on. So somebody wasn't, prohibited, and then they were the next day. That doesn't violate the Constitution to prosecute that person in that manner. But that's just really not the intent of the bill. And that's why I mentioned I certainly am open to any amendatory language to make sure that that wouldn't be the case here. This would be going forward.
Okay, thank you for that clarification.
We do have a couple more questions. I'm going to go to Assemblywoman Cohen and then back to Vice Chair Wynn. And I just saw Assemblyman Orentlicker raise his hand, so we'll go to him third. Go ahead, Assemblywoman Cohen.
Thank you, Chair, and thank you for the presentation. My question is probably not for the presenters. I don't think you have this information, but I understand Mr. Jones is on the phone for the Clark County District Attorney's Office. And I'm wondering, Mr. Jones, if you can, I don't know if you're going to have this information currently, but if you can get for us information about how the Anderson case has affected other courts in Clark County. So for instance, I know that with some of my domestic cases, the custody case has been on hold since Anderson because there was a DV allegation in Henderson. We're waiting for that trial. So that case has kind of lingered for the domestic situation for more than a year now, well more than a year. So can you please just kind of get us some general information about that? I'm not exactly sure if this is affecting any other civil cases, but any place where you could tell us how Clark County is affected, I'd appreciate that.
Thank you, Assemblywoman Cohen. And I do believe we'll have Mr. Jones on the phone at some point in this meeting. So Mr. Jones, if you're out there and you're listening, if you're able to address that in your testimony, that would be most welcome. And if not, if you could get that information for us. I'll go back to Vice Chair Wynn for a question.
Thank you. It's me again. I just have a couple of questions about subsection 4 of that expanded or kind of clarifying definition. It's the child or parent of one another. Did you take that language from somewhere? I find that to be really like unclear, like who that applies to. Can you kind of expand on what that section 4 applies to, why it's not included in the federal definition, why it needs to be put in here, and if you're open to having language that's a little bit more clear in what that defines?
Mark Skifalakwa, yes, absolutely. Right now in the federal law, it's a little odd. It includes in the definition of domestic violence a parent battering a child, assuming they're both adults, parent hitting child, but it doesn't go the other way, child hitting parent. We have seen a lot more child-parent relationships. People are moving in together, living with one another during the pandemic. I've seen an increase in domestic-related crime in with the parent-child relationship, both adults, obviously. And so that's what was looked to be captured there. That being said, absolutely, we're open to an admonitory language to make sure that's clear.
Thank you. That's all I have right now.
Thank you. Let's go next to Assemblyman Orentlicker.
Thank you, Mr. Chair, and David Orentlicker for the record, Assembly District 20. And I just appreciate some clarification on this retroactivity concern, as it seems to me that's not something that's going to be created by this bill. It's already in 202.360 that if you've been convicted in another state of the crime of domestic violence, we're already have prohibited possession. And your discussion about narrowing the scope of crimes that applies to would seem to limit the retroactivity concern rather than expand it. So could you just say a little more about that?
Mark Skifalakwa, yes. As far as that concern, you're right. Somebody in a different state who commits the crime of domestic violence, as long as it's one of the qualifying relationships, is prohibited there, and they're going to be prohibited here no matter how we change this definition. And as far as the other times they could be prohibited federally, if they had a simple battery or a simple assault with a qualifying relationship, that is true. They would be prohibited federally, but actually not under our state law. We're trying to limit this to the Anderson decision, to the crime of battery, domestic violence solely.
May I follow up?
Yes, please.
So from what my reading and what you're saying then, for those who are concerned about retroactivity, you're giving some protection rather than creating new problems.
Mark Skifalakwa, yes, that is our intent.
Okay, let's go to, I think Assemblyman Wheeler will give you the final question on this one before we move on to testimony.
Okay, thank you, Mr. Chairman. Just thought of this. I would have asked it earlier. I thank you for the leeway. In the 2019 session and in this session, we've been working a lot on criminal justice reform, trying to make things a little more fair. So with this bill, it seems we're expanding the definition of people who are breaking the law, basically, that we're going to be adding more people to these criminal roles. So I'm wondering, given all the criminal justice reform and the focus on racial injustice, et cetera, how is this going to affect the communities of color in Nevada when we see that most of the domestic violence cases seem to happen there? Do we have any numbers? Is this going to inordinately affect those communities?
Mark Skifalakwa, I don't know if it would inordinately affect the communities. I think the reality is that nowadays, as opposed to when the domestic violence laws were originally written in the mid-90s, frankly, less and less people throughout racial categories get married. More people are in non-married type of relationships, and I think that goes through any racial community. So I don't know, and I wouldn't think it would affect one group much differently than in others. But I don't have any numbers to answer your question directly.
Okay, thank you very much.
And I guess I would just say in response to that, it's been a while since I've practiced in criminal court, but domestic violence was certainly one of those crimes that I think really the clients that I represented came from all walks of life, all backgrounds. So I don't know that I can agree that most of those happen in certain communities. It was one of those crimes, much like driving under the influence, that seems to really span the gamut of our communities, at least in Clark County. So appreciate the question, but I think I would disagree with the premise of the question.
Well, maybe I said it incorrectly, Mr. Chairman. What I'm saying is I don't know the numbers. So, but what we've heard throughout this session and through the last session is that the communities of color are inordinately affected by some of these laws. So that's what I was getting at. Let's find out, before we move on this, if that happens to be the case here.
I appreciate that, Assemblyman Wheeler, and I do agree with you there that I think the criminal justice system as a whole does disproportionately impact particularly communities of color. I would just note that in my experience, domestic violence and DUIs are the two that I think are kind of the exceptions to that general rule. But again, I can only speak for Clark County and my limited experience. So I think the question is a relevant one. I just don't know whether we have statistics on that or not. But Mr. Skifalakwa, if you do have any of that kind of information, I'm sure you don't have it with you now, but would welcome you to present that to committee at a later date.
Thank you, Mr. Chairman.
Okay, I would like to move on to testimony. There may be more questions out there, and I appreciate that. And so I would ask anyone else with questions to follow up. There's a lot of questions about the retroactivity piece, and I don't want to go too far down that rabbit hole today because we've got a lot of folks who would like to be heard on this bill in testimony. So I want to thank the City of Henderson and Judge Glasson for being here to present. I'll ask you if you're able to sit tight, and we'll come back to give you concluding remarks once we get through the testimony on the bill. So at this time, I'm going to open it up for testimony in support of Assembly Bill 42. And let me first ask, is there anyone with us on the Zoom who would like to give testimony in support of the bill, who has not already spoken? Okay, I don't see anyone turning a camera on or unmuting. So BPS, could we go to the phone lines, please, and see if there's anybody there who would like to testify in support of Assembly Bill 42?
Good morning. Thank you, Chair. For callers wishing to testify in support of Assembly Bill 42, please press star 9 now to take your place in the queue. And we will begin with the caller with the last 3 digits of 648. Caller, please slowly state and spell your name for the record. You have 2 minutes and may begin.
Thank you, Chair Yeager, members of the committee. My name is John Jones, John Jones, here on behalf of the Nevada District Attorneys Association and the Clark County District Attorney's Office. We are here in support of AB 42. And I want to start off by thanking Nicole Rourke and Mark Skifalakwa and the City of Henderson team for bringing this bill and keeping us updated on its progress. Mr. Skifalakwa is correct that 3 large municipalities in Southern Nevada handle more DV cases than the Clark County District Attorney's Office. And thus we support their efforts to clarify the law with regard to these jurisdictions and how they handle these trials. Instances of DV that occur within municipalities are best handled by those municipalities. Mr. Skifalakwa also did a great job articulating the problems with using the current federal definition in the firearm prohibited person statute. We support the provisions of this bill that move away from the federal definition of domestic violence and closer to the state version. Finally, we support Section 1 of the bill, which consolidates any misdemeanor domestic violence to the underlying felony case for purposes of trial. This makes sense from a victim standpoint and from a judicial economy standpoint. And to answer Assemblywoman's question, between September of 2009, when the Anderson decision came down, in the first part of 2020, the Justice Partners worked hard to get a system in place for misdemeanor jury trials. We contracted with the District Court Jury Services to get this system in place. Unfortunately, right as we got the process off the ground, the COVID-19 pandemic hit. And much like felony trials, the MISTO trials were on hold for a greater part of 2020 and a few weeks of this year. So about a month ago, a little over a month ago, we began at least summoning in juries again. So we hope to get the program off the ground soon. It's my understanding in between the various governor's orders with respect to pauses, we were able to get a handful of misdemeanor jury trials done to completion. So if you have any questions about how we handle these cases, I'd be more than happy to meet with you on an individual basis. But again, wanted to say that the DAs are here in support of AB 42. Thank you, Mr. Chairman.
Thank you for your testimony, Mr. Jones. And BPS, before we go to the next caller, could we just pause for a brief second? I overlooked we have Ms. Helbert with us on the Zoom who did want to testify in support. So I'm going to go to her next to provide her testimony, and then we'll go back to the phone line. So I'm sorry for overlooking you, and please go ahead with your testimony.
I was a little slow on the Zoom. Thank you, members of the committee. My name is Carlene Helbert, CarleneHelbert, and I am a deputy city attorney for the city of Las Vegas, testifying in support of AB 42. So the committee is aware our jurisdiction is the largest municipality in the state. We have about 3,500 to 5,000 battery domestic violence referrals each year. And so again, the committee is aware 2 of our courts have actually held that they do not have the authority to conduct jury trials, which puts us at a standstill. We're essentially waiting for a Nevada Supreme Court ruling to tell us that we can do jury trials so that we can begin charging under the state statute. What's problematic with that is that the Anderson decision that kind of got us here took 4 years to get to from filing until decision. So 4 years with our numbers is almost 20,000 victims that do not get the protection of our state statute. And even if it goes to the Supreme Court, there is a risk that they can rule that no, it's the legislator's authority to give us the ability to conduct jury trials. And then we're left waiting, kind of like this last session, for you guys to convene again for us to discuss this. So it's very important that you guys fix within a matter of weeks, which we've been holding up for several years, kind of a thing. And I just wanted to give some context for prosecuting these cases in the interim that makes it extremely difficult. As this committee might be aware, battery domestic violences are mandatory arrests and mandatory prosecution crimes, which means oftentimes when these cases go to trials, victim and defendants are still together. And I've had victims arrive with their abusers, sit in court with them, get up, take the stand, testify of abuse as the defendant sitting in court, then get up, get in the car and go home with that person. And as a prosecutor, I have to watch this person leave with somebody who's committed violence against them, knowing that they're going to a house that has firearms in it. And I have to think to myself, is that victim actually safer for having gone through this process? And I think with the implementation of AB 42, I can answer, yes, they are safer for having gone through this process. But without it, I'm left unsure, and I'm even more afraid for her safety. And that's not even including victims who actually have left their offenders and who are afraid of retribution. And we sit and we put together a safety plan with them, but I have to tell them that right now, because of the split of authority in law, that no, he gets to keep his guns, even if he's convicted. And so I want to thank Henderson for putting this bill together. I look forward to working with them to amend the effective date. I do think that it needs to be pushed up upon passage. And I would like to welcome you all to reach out to me regarding your retroactivity concerns. I think there's some specific language that can be included about being afforded a jury trial right for it to be essentially effective. And so please feel free to reach out to our office. Thank you.
Thank you for your testimony, Ms. Helbert. Appreciate that and appreciate your patience this morning. Okay, BPS, having covered all the supportive testimony on the Zoom, could we please go back to the phone and take the next caller in support of Assembly Bill 42?
Thank you, Chair. We are currently on support for Assembly Bill 42. If you have recently joined the call and would like to testify in support, please press star 9 now to take your place in the queue. And we will go with the next caller with the last 3 digits of 540. Caller, please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Chairman Yeager and members of the committee, good morning. My name is Serena Evans, SERENAEVANS, and I'm the policy specialist for the Nevada Coalition to End Domestic and Sexual Violence. And we're here today in strong support of AB 42. We appreciate the City of Henderson collaborating with other jurisdictions to bring this bill in response to the Anderson v. State ruling. We are in favor of AB 42 as it establishes in state statute that municipal courts have the authority to conduct jury trials. This will ensure that all municipal courts are able to hold domestic violence offenders accountable through jury trials. It is imperative that domestic violence offenders, when convicted, lose their rights to bear or purchase firearms because of the risk to domestic violence victim survivors. We know that offenders having access to firearms increases victim survivors' risk of homicide by 500%. This bill will make sure that there is uniformity in the processing of domestic violence cases in all municipal courts throughout the state. Thank you very much.
Thank you for your testimony, Ms. Evans. BPS, could we take the next caller, please?
Thank you. Next caller with the last three digits of 196. Caller, please slowly state and spell your name for the record. You have 2 minutes and may begin.
Good morning, Mr. Chairman, members of the committee. This is Eric Spratley, ERIC-SPRATLEY, the Executive Director of the Nevada Sheriffs and Chiefs Association. We are here in support of AB 42. Thank you.
Thank you for your testimony, Mr. Spratley. BPS, next caller, please.
Thank you. Next caller with the last three digits of 938. Caller, please slowly state and spell your name for the record. You have 2 minutes and may begin.
Thank you, Chair and committee members. My name is Ariel Edwards, ARIELLE-EDWARDS. I'm the Government Affairs Specialist for the City of North Las Vegas, testifying in support of Assembly Bill 42. I would like to thank the bill sponsor for working with the city, and we support the amendment that has been proposed. AB 42 gives additional clarity to the NRS as it pertains to prosecuting battery domestic violence cases. As we understand AB 42, if the City of North Las Vegas wants to continue prosecuting battery domestic violence cases, that jury trials will be required unless waived by the defendant. With that being said, I would like to state for the record that the City of North Las Vegas has submitted a fiscal note regarding AB 42. The fiscal impact would be substantial due to the need for retrofit and expansion of our municipal courts to house these cases, and we support the effective date for passage in the bill to accommodate these cases. Again, we'd like to thank the City of Henderson for working with us, and we look forward to continue conversation regarding this piece of legislation. Thank you so much for your time.
Thank you for your testimony, Ms. Edwards. BPS, are there other callers in support?
Yes, Chair. We will go with caller with the last three digits of 294. Caller, please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Chairman Yeager and members of the committee, for the record, Callie Wilsey, Senior Management Analyst with the City of Reno. My name is CALLIWILSEY. We are here in support of AB 42 today with the amendment presented by the City of Henderson. We want to thank the bill sponsor for working with us to resolve a minor operational issue we had related to the role of the police chief versus the chief marshal in our local system. The Reno Municipal Court has already converted one of its courtrooms to accommodate the needs of jury trials, and this legislation allows us to continue our partnership with the Second District Court on jury summons. The City of Reno will be able to operate in compliance with this legislation and recent case law. Thank you again for the City of Henderson for working with us and for the opportunity to provide testimony today. Thank you.
Thank you for your testimony, Ms. Wilsey. BPS, let's take the next caller, please.
For callers wishing to testify in support of Assembly Bill 42, please press *9 now to take your place in the queue. And we will go with caller with the last three digits of 451. Caller, please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Liz Ortenberger, Ortenburger. I am the CEO for SafeNest. Thank you to the committee and Chairman Yeager and the City of Henderson for bringing this bill forward. SafeNest works with victims, batterers, and children affected by domestic violence and has done so since 1977. In addition to our comprehensive services, we work directly with the District Attorney's Office and have 2 advocates placed in Las Vegas Justice Court. SafeNest serves over 25,000 victims of domestic violence every year. As you heard from Serena with the Nevada Coalition, studies show domestic violence is much more likely to become deadly when there is a gun in the home. In fact, up to 500% more likely to become deadly. And it's important to remember that the gun is not only a tool for homicide, it is also a tool for intimidation and control. We hear from victims about guns being placed in their mouths in order for them to take care of what a batterer is looking for. We hear stories of guns being pointed at the family pet or at a child in order to gain control in the relationship. The 3 largest municipalities in Clark County, which carries 85% of the domestic violence cases for the state, have had to create a loophole in which firearms are not being confiscated from convicted batterers. This leaves not only victims of domestic violence, but also police at an increased risk for homicide. In 2017, the National Law Enforcement Officers Memorial stated that domestic violence is the most dangerous call an officer will go on, with 136 officers being killed, as opposed to 80 who were killed in drug-related arrests. While SafeNest understands the municipalities need to continue to operate since the Supreme Court decision in 2019, on behalf of the 24 victims murdered by domestic violence, and 16 of those, including a 1-year-old little boy, at the hands of a gun, including domestic violence, it is time to fix the loophole and make both victims and police safer. Thank you.
Thank you for your testimony, Ms. Ortenberger. BPS, are there other callers in support?
For callers wishing to testify in support of Assembly Bill 42, please press star 9 now to take your place in the queue. And Chair, there are no further callers for support at this time.
Thank you, BPS. I'm going to close supportive testimony. Before we move on to opposition, I wanted to let the committee know that I've been in discussions with our legal counsel, Mr. Wilkinson, who is busy drafting bills, but also trying to keep tabs on what we're doing here in the committee. And I just wanted to point the committee, if you have the original bill in front of you, AB 42, I wanted to point you to the end of the bill, section 17, and that section addresses the retroactivity question in the bill. And essentially what it says is that the amendatory provisions of this bill only apply if an offense was committed after the effective date of the bill, which currently stands at January 1, 2022, or if the offense was committed before that date but was pending or unresolved. So from legal, the concerns that were raised about potential retroactivity are taken care of in section 17. And I think that does align with the City of Henderson's intent that the bill just be applied going forward. So I wanted to note that for the record. And if anybody does have follow-up questions about that section, feel free to come see me, or we can visit with Mr. Wilkinson when he has a moment to come up for air from drafting bills. So hopefully that is helpful in terms of the retroactivity question. And at this time, I'm now going to open opposition testimony. I don't think we have anyone on the Zoom in opposition, but I'm just going to wait a brief moment to make sure I'm right about that. So if you are on the Zoom and you're in opposition, if you could turn your camera on and unmute. Okay, I don't see anybody on the Zoom. So BPS, I believe we have some folks in opposition on the phone line. So if you could please go to the phones and take the first caller.
Thank you, Chair. For callers wishing to testify in opposition of Assembly Bill 42, please press star 9 now to take your place in the queue. And we will begin with caller with the last three digits of 801.
Hello, thank you for the opportunity to speak today. My name is Michael Pariente, Michael. Last name is spelled P as in Paul, A as in Apple, R as in Roger, I as in Island, E as in Edward, N as in Norman, T as in Tom, E as in Edward. I want to thank the members of this committee. I represent the NACJ today. We oppose AB 42. It's still not a complete expansion of jury trials for battery domestic violence offenses in municipal courts throughout the state. It's unacceptable that municipal courts in smaller jurisdictions may opt out. Either this bill needs to be amended to state that any court hearing battery domestic violence trials must provide for a jury trial, or all misdemeanor battery domestic violence counts must be filed in justice court. We believe it should not be discretionary for municipal courts to choose to not have a jury trial or not. The amendment also attempts to clean up language removing 18 U.S.C. Section 921A33, but even the way that they have listed the four categories of who would be covered by the battery domestic violence statute and the relationships that would get a jury trial needs to be cleaned up, specifically the language related to the parent and child, which is Section 4 in Section 13. The amendments do not address our concerns that procedures for criminal trials for misdemeanors must be identical to those for district court trials. We reiterate that the right to trial by jury attaches to the charge of battery constituting domestic violence. The jury trial right should not be withdrawn based upon the status of the defendant. In fact, the Anderson decision never addressed the status of the defendant, only that Mr. Anderson was entitled to a jury trial because the offense was indeed serious. There's an amendment that proposes that jurors from the entire county rather than municipal boundaries, if the municipal district has a small population, we are concerned that may serve to eliminate diversity of jurors. Also, we are not in agreement with the number of peremptory challenges and alternate jurors that are being proposed in the amendment, and would prefer 12 jurors. Although the language says minimum 6 jurors, it's certainly better than a misdemeanor jury has 6 jurors. We think we continue to take the position about we take no position rather about consolidating battery domestic violence charges in district court with felonies and gross misdemeanors. We believe that a defendant charged with battery domestic violence should not have to demand a jury trial. Defendants don't have to demand a jury trial for gross misdemeanors or for felonies. Finally, 12 jurors should be required instead of 6. A defendant in a civil case who's being sued for more than $15,000 has the right to an 8-person jury, though he or she is not facing incarceration, not facing a criminal conviction, nor facing the loss of a constitutional right. Yet a person charged with battery domestic violence faces up to 6 months in jail and the lifelong loss of a constitutional right. Again, a person facing battery domestic violence only gets 6 people to hear that on their jury. Thank you for your time.
Thank you for your testimony, Mr. Pariente. BPS, let's take the next caller, please.
Next caller with the last three digits of 407. Caller with the last three digits of 407, please press *6 to unmute yourself and begin your testimony. Caller, please.
Thank you, Mr. Chair.
Spell your name for the record. You have 2 minutes and may begin.
Thank you, Mr. Chair, members of the committee. For the record, I am Randy Thompson, RANDITHOMPSON, representing the Nevada Firearms Coalition. On behalf of tens of thousands law-abiding firearm owners in Nevada, I'm speaking in opposition to AB 42. I have provided a brief written statement for the record, but I'd like to state a few concerns. First, let me state that we want to protect the rights of victims of domestic violence, and we understand the intent of this bill. Thank you, Mr. Chair, for the clarification on Section 17 related to retroactive. That is helpful, and that is a big concern of ours. So I'm happy to hear that. And look forward to having that discussion a little bit more. Regarding the change in Section 13, we're still concerned that the types of disqualifying misdemeanor crimes should be limited to those with an element of physical force or the threat of use of a deadly weapon, not offenses that have no element of force or violence, such as trespassing. The Nevada Supreme Court has made it clear people accused of misdemeanor domestic violence should have the right to a jury trial if their Second Amendment rights are in question. So we stand by the intent of this law to allow due process if your Second Amendment rights are threatened and you are entitled to a jury trial. We appreciate the opportunity to present our concerns and are willing to work with the sponsors to find a way what appears to be truly a kind of a budget issue for municipalities to provide jury trials. But we support the intent and we look forward to working with the sponsor. Thank you, Mr. Chair and committee members, for your service to our state.
Thank you for your testimony, Ms. Thompson. And I'll note for committee members that the letter that was referenced in the opposition testimony can be found on Nellis. That is a letter in opposition from the Nevada Firearms Coalition. BPS, let's take the next caller, please.
Thank you. Next caller with the last three digits of 502. Caller, please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Mr. Chair and members of the committee, for the record, Dan Reed, DAN REID, Western Regional Director with the National Rifle Association. I appreciate the committee and the proponents of this bill for the robust conversation. We have been working with the city of Henderson and trying to get to some agreeable language. However, our opposition to AB 42 still stems from Section 13, both in the original bill, the expansion of the prohibited categories, as well as in the amendment. We still feel this goes beyond the federal law. The federal law is important because it provides consistency. There's clear elements as far as what is both domestic and violent to be a lifetime prohibition for firearms. We will continue to work with the sponsors. We continue to have concerns about what this could do, especially for many people that may come to visit the state. And we also have concerns about, I understand that this bill is limited in retroactivity looking forward for crimes that would meet under Section 13. However, the federal law does continue to look backwards. And so with that, we are in opposition, but we will continue to work with the sponsors. Thank you.
Thank you for your testimony, Mr. Reed. And I'll note for committee members that there is also a letter in opposition from the National Rifle Association that can be found on Nellis under the Exhibit tab. BPS, let's take the next caller in opposition, please.
Thank you, caller, with the last three digits of 611. Please slowly state and spell your name for the record. You have 2 minutes and may begin.
Good morning, Chairman Yeager and members of the Assembly Judiciary Committee. This is John Piro, Johnpiro, from the Clark County Public Defender's Office. We have always believed that the right to a jury trial for any crime or deprivation of liberty is important because liberty is our most sacrosanct thing that we have. Muni courts should be allowed to have jury trials because the justice that you get in one part of the city should not be different than the justice that you get in another part of the city. There is a cure to this problem, but the bill as written, even with its amendments, are not the cure. But I think we can get there if we continue to work on that. And I'd like to thank Mr. Skifalaqua for bringing this bill forward and talking with us about it. But we think that more conversations need to be had to get the bill there. My colleague, Mr. Pariente, mentioned a lot of the problems with the bill. I'm just going to hone in on the one again, Section 4, the amendment to peremptory challenges. Reducing the number is not okay. Jury selection is one of the most important parts of ensuring a fair trial. There hasn't been a slew of trials where we've been using up all these jurors in the community. I think when the decision first happened, we had 5 trials and there were 4 not guilties in the whole state. I will say that Mr. Skifalaqua said he consulted with the Justice Court, but he certainly didn't consult necessarily with the people that are actually picking the juries here, which would be us in this case. I want to assure the committee that even though there's been problems with here, the domestic violence statute, because of the Anderson decision, prosecutions haven't halted. People have continued to be prosecuted under this. So there hasn't been this widespread halting of prosecution. Hopefully we can work the issues out in this bill and allow muni courts to conduct jury trials. Thank you.
Thank you for your testimony, Mr. Pirro. BPS, let's take the next caller in opposition, please.
Next caller with the last three digits of 318. Please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Good morning, Chair Yeager and members of the Assembly Judiciary Committee. This is Kendra Birchie, KendraBertschy with the Washoe County Public Defender's Office. I want to thank the sponsor for bringing this bill forward, and for starting to engage in the discussion with us regarding this bill. And we hope to continue that discussion to ensure that the law that we are passing will work across the state of Nevada. I understand that the intention of this bill is to allow municipal courts to provide jury trials for domestic battery cases, but this bill will impact anyone charged with a domestic battery, regardless if they are charged in municipal court or another court. As indicated, your right to a jury trial is an incredibly crucial right for those accused of a crime. In my discussion with the sponsor yesterday, it was my understanding that the intention of this bill is to ensure that everyone has a right to a jury trial based on the nature of the relationship between the accused and the complaining witness, not the status of the accused. The status of the person accused has never been an element of this offense. The relationship is what is at issue. I'm very concerned if we are making that distinction or requiring there to be litigation, which would be very costly and adding additional time and burden upon everyone. The Anderson case, as Mr. Pariente indicated, was clear that status is not an element of this charge and should not be determined upon who should be allowed to have a jury trial. Regarding Section 13, I believe that it's been indicated that there's just some vagueness regarding subsection 4 in that section regarding that parent-child relationship. And I believe that it is necessary to clean up that language in order to ensure that we are charging, or that the individuals who are convicted of this charge have that information and that knowledge. The Sixth Amendment secures to persons charged with the crime the right to be tried by an impartial jury reflecting a fair cross-section of the community. We believe that Section 4, which requires only 2 preemptory challenges, is very detrimental when considered with the Sixth Amendment. In my research, I did not find a single state which has jury selection for misdemeanor cases that limited your preemptory challenges to only 2. This is extremely important when ensuring that we are picking jurors who are fair and impartial. Additionally, I would just note to Assemblywoman Cohen's question, to my knowledge, in part due to COVID, neither Sparks Justice Court nor Reno Justice Court has conducted a jury trial for domestic battery. Thank you for your time and your attention today.
Thank you for your testimony, Ms. Birchie. BPS, let's take the next caller, please.
Next caller with the last three digits of 037. Please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Tanya Brown, TONJABROWN, advocates for the inmates and the innocent. We echo the comments made by the previous callers in opposition of this bill. I think it will also give those a chance who have been accused to prove their innocence in court. There are times, I'm not saying at all times, but at times the supposed victim will make up allegations of abuse, domestic violence, and we believe by having a jury trial, it can show and prove one's innocence. Thank you. And have a great day.
Thank you for your testimony, Ms. Brown. BPS, let's see if there are additional callers in opposition, please.
Thank you, Chair. For callers wishing to testify in opposition of Assembly Bill 42, please press star 9 now to take your place in the queue. And Chair, there are no further callers for opposition at this time.
Thank you, BPS. I will close opposition testimony, and I will now open neutral testimony on Assembly Bill 42. I believe we have someone with us on the Zoom, Miss Souza Llamas. Are you there, and would you like to provide testimony in neutral, please?
Good morning, Chair Yeager and members of the committee. I'm Erica Souza Llamas, and I'm the Records Bureau Chief in the Department of Public Safety, Records, Communications, and Compliance Division, which houses the Central Repository for Nevada Records of Criminal History. I'm here today to testify in neutral for AB 42. I have with me today Nicole Lubitch, who oversees our Brady Point of Contact program, to assist in answering any questions that committee members may have. Section 13 of Assembly Bill 42 removes the federal definition of domestic violence and replaces it with a definition of an act which constitutes domestic violence pursuant to NRS 33.018. By making this change, the number of offenses that will be considered when determining firearm eligibility may substantially increase the number of delays. Currently, the federal definition contains 3 criteria that must be met to disqualify an individual from obtaining a firearm. If this bill is enacted as introduced, the criteria will increase to 15 prohibitors, thus increasing research that will impact the workload for the division, as well as the local criminal justice agencies around the state and nation, due to the division submitting requests to these agencies for information to ascertain the status for determination purposes. An increase in research in this area will also result in an increase in denied or unresolved individuals. The impact of the additional workload as a result, should AB 42 pass, may necessitate additional staff in the Brady Point of Contact Firearms Program. We'll be reaching out to Mr. Skifalakwa to discuss the impact of this bill on our division. This concludes my testimony, and we're happy to answer any questions that committee members may have.
Thank you so much for that neutral testimony. Committee members, any questions for, I see we have one from Assemblyman O'Neill, so let's go there for a question.
Thank you, Mr. Chair. And this is to Ms. Llamas. What do you expect? I guess it's 2 parts. What would be the physical impact? You'll have to increase staff, and what would be the time delays? Because if I remember, you only have 3 days to respond and either pass or disqualify a person from a purchase.
Erica Souza Llamas, for the record, that's correct. We have, per the federal law, we have 3 days to respond to provide a determination to the dealers. We don't know what the impact time-wise would be on our division with this. We haven't done any studies.
Would it be fair to say that you may have trouble meeting that 3 days?
Erica Souza Llamas, for the record, there is a possibility that we wouldn't be able to meet the 3 days. It would most likely increase the amount of unresolved cases that we have.
Have you supplied a physical note on this bill?
Erica Souza Llamas, for the record, no, we have not. We have not been asked for one at this time.
Thank you. I appreciate that. And thank you, Mr. Chair, for allowing the questions.
You're welcome, Assemblyman. Are there other questions from committee members? I don't see additional questions, so I want to thank you for being here and offering neutral testimony on the Zoom this morning. I think that concludes the neutral testimony on the Zoom. BPS, could we go to the phone lines to see if there's anybody there who would like to give neutral testimony?
Yes, thank you, Chair. For callers wishing to testify in neutral, please press star 9 now to take your place in the queue. For callers wishing to provide testimony in neutral of Assembly Bill 42, please press star 9 now to take your place in the queue. And Chair, the public line is open and working. However, there are no callers for neutral at this time.
Thank you. Thank you, BPS, for helping us to manage the phone lines this morning. I will close neutral testimony, and I'm now going to go back to our presenters from City of Henderson and then to Judge Glasson for any concluding remarks on Assembly Bill 42. So we'll start with you, Mr. Skifalakwa.
Thank you, Mark Skifalakwa. I do want to very much thank the chair and the vice chair. I've had conversations with you both these past few years on this difficult issue facing our judiciary, and I do appreciate your insight. I just wanted to clarify a few things, but I think there is some good news here. I heard all the opposition, but I really didn't hear anybody say that anyone's really against giving municipal courts the authority and the rules to proceed with these trials. And so I think that is a good thing. And I do think any other differences can be worked out going forward. I did want to clarify though some things Mr. Pariente said, and he may not have heard my original testimony, so I understand that, but the goal, and I worked with the public defenders on this several months ago, was that they would not have to file a written demand if there's a constitutional right to a jury trial like they would now. So that is already fixed in Section 2 of the bill. As far as this concern about cities opting out, if I could just be clear on that, this doesn't force cities to have jury trials, but again, like I said, if you're a prosecutor and you're filing a domestic violence charge that has an associated penalty of firearm prohibition, your court is going to have to provide that level of due process to a defendant. So it doesn't force a prosecutor to do it. If a certain city could not handle that accommodation, they would have to go to the county, who has concurrent jurisdiction on state law. And so there'd certainly be no issue or violation of law there. This bill overall, though, is about protecting folks in domestic violence situations, but also giving those who are accused of which the due process that they're owed. I would also say that I know there's been some comments about this expanding to a lot of different other types of acts. Happy to make this clear. The goal of this bill is simply battery domestic violence. And not only that, you would have to be both charged and convicted of that one offense to be prohibited under this change. This would not apply to trespassing or coercion or other types of offenses. So I just wanted to be clear, absolutely clear on that, and more than happy to make it clearer in the bill if needed. Currently, we do prosecute for dating relationships in our courts. That's something new. That wouldn't be a new prosecution. It was just be included in the amendment. That is all I have. I do want to thank, again, the committee and everyone's comments today. Ms. Rourke and I both appreciate all of your hard work.
Thank you, Mr. Skifalakwa. Judge Glasson, you've been sitting patiently through the hearing, so we'll give you the last word in concluding remarks.
Thank you, Chair Yeager. This is Richard Glasson on behalf of the Tahoe Justice Court and the Nevada Judges of Limited Jurisdiction. I thank members of the committee for their patience today. This proposed amendment would allow access to justice in our rural courts in counties to continue to provide jury trials for battery domestic cases with a lot of ease and not being required to pick on the same people week after week after week, cast a much larger net for our townships that are located in high tourist areas. And I thank you for the time and your patience today.
Thank you, Judge. Appreciate that. And thank you to the three of you for presenting, and Mr. Skifalakwa. I hope it didn't feel too uncomfortable to have the tables turned on you. Usually you're the one asking the questions in court, and we had a chance to ask you some this morning. So we appreciate that. And it sounds to me like there may be some additional conversations that need to happen around the bill. So I just ask you to keep me updated on where things are as we march towards our April 9th first committee passage deadline. And again, thank you for joining us this morning, and I wish you all a great rest of the day.
Thank you.
Thank you.
So I will close the hearing on Assembly Bill 42, and that takes us to our final item on the agenda today, and that item is public comment. By way of a reminder, we reserve 30 minutes of public comment at the end of each meeting for public comment. Callers on the public comment line will have 2 minutes to provide comment, and public comment is a chance for individuals to raise matters of a general nature that are within the jurisdiction of the Assembly Judiciary Committee. It is not a time to testify on bills that have already been heard. BPS, could we go to the phone lines to see if there's anybody there who would like to give public comment this morning?
Thank you, Chair. For callers wishing to provide public comment, please press *9 now to take your place in the queue. Caller with the last 3 digits of 556, please slowly state and spell your name for the record. You have 2 minutes to speak and may begin.
Anne Marie Grant, ANNEMARIE GRANT. sister of Thomas Purdy, who was killed by Reno police, hogtied for 40 minutes during a mental health crisis and then asphyxiated to death while still hogtied by Washoe County Sheriff's Office. Today, I'd like to talk about Artia Porter, who was 22 years old when he was killed during a mental health crisis by Washoe County Sheriff's Office, Reno Police, and Sparks Police Department. Porter originally called 911 to report he was suicidal because his daughter had died and his wife was pregnant with another child. The investigation showed that he had no daughter or wife. Police were very familiar with Artier. His family described him as a schizophrenic, and the police had had several encounters going all the way back to 2013 involving Artier and his mental health situations. In February of 2016, he had called 911 and expressed feelings to kill somebody. He was not on his medication and was taken to a mental health facility. In February 20th, 2016, he called 911 stating he felt like he might stab someone. He was not on his medications, and he was also taken to a mental health facility that day. On July 1st, 2015, Sparks Police responded to a group home where Artier was living, and he was suicidal. He was taken to NNAMHS, and in 2014, law enforcement had several encounters with him as well. In the Washoe County District Attorney Chris Hicks' report justifying the shooting, he states that the criminal and mental illness history of a person shot in an OIS is not relevant in OIS reviews. However, in this case, officers were professionally aware of Porter and his history, making it relevant to their decision making. So they knew this man had made prior threats before and never followed through with them. But this time, they decided when they heard the word gun that the man had a gun. All they heard was gun. They didn't hear person in crisis. They lost sight of that. And he was shot at 24 times by multiple officers. Please do not support bills that protect bad policing. Please support bills that promote transparency and accountability for families like myself and our peers. Thank you.
Thank you for your public comment, Ms. Grant. BPS, is there anybody else for public comment this morning?
For callers wishing to provide public comment, please press star 9 now to take your place in the queue. Chair, the public line is open and working. However, there are no further callers at this time.
Thank you so much, BPS, for helping us manage the phone lines this morning. I will close public comment. That takes us through everything on our agenda. Anything else from our very hardworking and dedicated committee members before we talk about the rest of this week? Okay, I don't see anything. Thank you, committee, for getting through that bill this morning. I know that was quite a bit technical for folks who don't practice in this area, but I thought the questions were thoughtful, and I think we are going in the right directions in terms of reaching a solution for the Anderson case. So in terms of the rest of the week, we have a meeting tomorrow. We'll be starting at 8 o'clock. Just so everyone knows, we'll take those bills out of order. So I'll be presenting one of the bills first, and it should be rather quick. So our vice chair will step in and chair that portion of the meeting, and then we'll take the second bill. And then we're still working on Friday's agenda. I do suspect we're going to hear anywhere between 1 and 3 bills, and perhaps have a work session as well. So we're going to start at 8 o'clock on Friday because I need to make sure that we finish the meeting before any potential floor session we might have. And then we are working on next week as well. So I don't have agendas yet posted for next week. I'm not sure what that looks like quite yet, but hopefully I will know tomorrow, or if not, I'll certainly know on Friday and I'll be able to tell you then. So thank you again, committee. I will see everyone back here tomorrow morning at 8 o'clock. This meeting is adjourned.